Today we have with us James Lee, the CEO of LegalMation. Thank you very much for joining us. Maybe just a few words before leaving you the floor. So LegalMation is a leading AI company in the legal field. They have developed tools to automate litigation tasks. I will let James further present it. They have collaborated with IBM's Watson. Yeah, and it's a company from Los Angeles. So without further ado, James, I'll leave you the floor and happy to have you with us today.
Hey, thank you very much. So, what I thought I'd do is just show you a short slide deck and really give you a little background of who we are and why we created the company. Let me see here. Let me just go and share my screen. I've been a lawyer for, about 25 years, and started my career at two large law firms in the United States. And then started my own litigation boutique with a few friends. That firm grew quite a bit. And what we learned as we were growing this litigation boutique and litigating against much larger firms is that we needed to use technology to leverage our limited resources against law firms with a lot bigger resources. And technology is a great equalizer when the other side's not using it. And for us, it was a force multiplier. And so about 4 years ago, we started to look at AI as a way of improving our own processes. And what we discovered is various applications of natural language processing where we thought, wow, this is really transformative. I mean, this is not just sort of an evolutionary step, but a revolutionary step in the way I think that we can handle legal work. And so, on this slide deck, you'll see that this whole idea is to sort of create a frictionless workflow. And that's sort of the way to think about it. And then I wanted to just share with you a few slides about what our philosophy is and why there's opportunities here. And so, what I thought I'd do is share with you Malcolm Gladwell's 10,000 hour rule. Well, not only is he Canadian, but I thought it was an appropriate sort of rule. But if you apply the 10,000 hour rule, and you look at lawyers and paralegals and in the insurance industry, claims adjusters, you're talking about very expensive human capital. And if they require about 10,000 hours of experience before they're competent, you're talking about a very expensive return on investment that you need to make as an industry. And so it creates two problems. Problem number one is that, by the way, I love this picture of this lawyer because he looks very mean. But lawyers and compliance managers have to recoup their investment, and so that's an expensive endeavor. And in the meantime, clients and stakeholders of organizations are held hostage because of sort of this quasi-monopoly or monopoly that lawyers have in the industry. Problem number two is a different problem, but it's related, which is the 80-20 problem. And if you actually look at the inputs of work in most organizations, and law is not exempt from this, 80% of the work hours that are actually invested in cases really only produce about 20% of the total worth. In other words, here on this graph, you'll see that the two people in white, they're delivering 80% of the value. Usually it's because it's strategic, high-level thinking, usually on the part of partners. But there's a whole support team underneath the partners, the associates, the paralegals, et cetera, that are doing a lot of the mundane tasks. And the issue is, or the question is, can you focus your effort in basically this 80% of the work effort that really only contributes to 20% of the value? And so, our view was, well, can we use technology to sort of target this sort of that segment of the workflow by targeting high volume work and reducing the production side of the equation? And so, if you actually looked at head-to-head results of what AI and machine learning and other technological solutions are versus what humans can do, it's quite staggering. The thing that I will be showing you today is our complaint analysis module. This is where we can take a lawsuit, drag and drop, and within 2 minutes, we have first final draft quality work product that you could use, compared to a team of people that would have taken 8 hours. That level of automation, that scale of automation is absolutely incredible. We also developed a data analytics platform where, because we're doing all this feature identification and extraction, we're now able to do really fine-grained analysis on data sets so that we can even give you sort of deeper insights into what firm you should hire, what the settlement ranges are, what are the utilization scores of particular lawyers at particular phases. We've also developed a matter profiling tool, which doesn't take that long for humans to do, but it's a pain point nonetheless. You can imagine an instance where, let's say, an automobile company wants to figure out make, model, year, and VIN of the documents that are before them. Well, we did that. And you can also figure out if you want to look at medical records, identify dosage or the prescription or the drug, et cetera. That's a type of matter profiling that people are doing almost manually, and you can use an AI machine learning platform to do that. And then we also created something called our discovery response creator. So this is to answer discovery questions, and the scale of improvement here is unbelievable, where whereas it would take you about 16 hours to answer questions based on fetching exemplars and looking at data sources, we've integrated all that to really sort of make this totally frictionless and really produce that work in 1 hour. These are just small examples among many that once you start applying technology to the manual, mundane tasks that lawyers and paralegals often do, there's tremendous opportunities for improvement in this space. And so what I will do today is actually show you an example of how this AI system works. And I'm actually going to run this lawsuit. This is an actual California lawsuit. A person named Albert Liu, the plaintiff, he walks into a Whole Foods supermarket and he buys a rotisserie chicken. He takes the chicken home, he bites into the gizzard of that chicken that contained a rock, and he breaks his teeth. And so Albert Liu, who ironically is a dentist, is now suing Whole Foods for negligence, strict product liability, breach of express warranty, a number of claims. This is a 15-page lawsuit, and it's a well-written lawsuit. And if I'd given this to one of my associates, guaranteed it would be about 8 to 10 hours of work that they would need to do before I would get an answer, request for production, interrogatories, and sort of all that sort of early stage stuff that associates are typically tasked with nowadays. And so in our system, it's a web-based system. You would pick the complaint analysis module where you upload the complaint and you get the answer in discovery. You click on that. And then we ask you to click the state, because each state has slightly different models. And then you drag and drop a PDF copy of that complaint into the system. And then the next question that our system is going to ask is pick a practice area. Again, another model. Each of these represent actually separate learning models that we've created. This is a personal injury lawsuit, and so you press go. So what's happening is that PDF copy of that complaint has to be reduced to a text readable file in order for any AI machine learning system to basically start reading it. So ironically, this is the longest part of the process, depending on the length of the complaint. But you can see here for a 15-page lawsuit, we're almost done with the OCR. But when the OCR is done, those text files are sent to a number of different AI and machine learning models that we've developed, including Watson. And what it's doing is it's identifying the claim, identifying the injuries, identifying all the important allegations, and then piecing that together through various other models that we developed that measure thresholds and relevancy, and then starts to make decisions that mimic what a young lawyer would be making under similar circumstances, and then producing the work product that a young lawyer would be doing at any law firm in the world, actually. So you can see now the AI system has it. It's going through that sort of decision-making identification process, and now we're done. This is what we call a verification page. We just want people to put in their internal client matter number for tracking purposes. But you can see that it picked the proper court, it picked the proper case number, it identified the names of the parties appropriately. We always assume the lead defendant is going to answer and ask questions of the lead plaintiff, and you can add and change that. Our system's really good at identifying who the opposing counsel is. So if you're a paralegal, you know this is a big pain point. So now you don't have to do that anymore. I'm going to just click here, a fictitious law firm, and then put a fictitious lawyer. And then once I'm done with that, just press go. And what's going to end up happening is in a matter of minutes, we're done. And you're going to get a zip folder of all that sort of early stage work that an associate or paralegal normally ends up doing. So you get an answer, you get your form interrogatories, special interrogatories, request for production. Let me just open up some of these documents so you'll see. So here you'll see that it's in the proper format for a California answer. And you'll see that there's a general denial, but then it's going to start marshaling all the appropriate defenses that would be relevant for the type of allegations in the lawsuit. And so you can see here that it's very specific. And in other words, it identifies features and then it basically will identify defenses. Here's an example. This is an excessive fines defense. And what that tells me is that there must be a punitive damages allegation in the complaint, which there is. And so that's what our system does. It's very intelligent in the sense that it's identifying signals or features and then executing results from it. When I was a young associate, this is a cut and paste job. Would have taken me an hour, maybe two, and in a matter of a couple of minutes, I'm done. But let me show you what the request for production look like. And this really underscores the power of AI and machine learning and how you can really use it to really just do this work really quickly. So again, this is the cover sheet. It's in the proper format. We're gonna go through the definitions, which is already laid out automatically. It's going to have instructions, ESI instructions, if you want that. But then it's going to start asking questions, and it's going to again identify features and allegations, and then based on that, figure out, well, this is an appropriate question to ask. And so you'll see that it knew that there was a negligence per se allegation, so it's going to ask a general question. And the philosophy of this was to ask very broad questions and then work your way down to more specific ones. And so it's going to ask you some questions about negligence, about whether the product was defective and how you knew that, the breach of warranty. A little bit later on, there's going to be some questions about his medical records because he's alleging permanent teeth damage. And so it's going to start asking questions about his medical care, medical records, medical treatment. But I'm going to scroll down here to the contention request. So, in America, and I'm assuming in Canada too, but you can ask very specific questions based on the language of the complaint. And most of these are very good, but I do want to sort of zero in on sort of what I think is to be amazing. And that's 53. And let me read that. Please produce any and all documents or communications that support, discredit, or relate in any way to your allegation that, as a manufacturers, retailers, or merchants of the rotisserie chicken, defendants knew or should have known that their gizzards of their chickens with access to the outdoors would contain rocks from foraging, as alleged in paragraph 43. Now, when I saw this, I was blown away for a couple of reasons. Number one, this is the most important allegation of the entire complaint. It actually explains why there's a rock in the gizzard. And I found out subsequently from people in the poultry industry, this is a real problem with chickens that forage outside, which is why they don't let chickens forage outside. But for Whole Foods, if they're selling organic chickens that have access to the outdoors, the plaintiff is probably right. They have to know about this. But number two, I wanted to check with our training team. I was like, hey, this looks pretty precise. Can you look in our training corpus and see if there were other cases involving rocks and gizzards? And they told me no, there wasn't, which is great news for me, because what that means is we've shown our system so many other product liability cases. It's been able to recognize patterns like this so that it makes quick work of identifying the important allegations, measuring it, and then putting it into a output like this that I as a lawyer I can accept it, I can reject it. Like if I didn't like 54, I can just delete 54 and everything auto numbers. A great way just to really speed up the process. So again, if I had given this to one of my associates, 8 to 10 hours of work before I would get this back, and now I have this like in 2 minutes. And now I, as a partner at a firm, I can start making decisions about whether I want to ask this question or not, really expediting the entire sort of speed at which we can basically deliver these products to market. So, that's just one example of how I think AI, and I think we all know this from what we've seen on TV and the news, that it is quite revolutionary in the sort of things that it can do to sort of tackle problems that lawyers are doing now, and lawyers are not exempt. So just a really good illustration of how I think things are going to change for the next several years to come. So with that, Mark, you want to go to the Q&A portion now?
Absolutely, yes. Thank you very much. That was a very interesting presentation, and it's truly impressive what you've shown us. And I'm sure a lot of us would be interested in go actually and read all these documents. But the examples you've shown, they're very interesting. Maybe a few questions I had following your presentation. First of all, and I ticked on that, you said that you have to convert this PDF into readable text, and your machine does that. Does that create noise for the AI processing after that? Doesn't that affect the results? Have you seen that?
Yeah, it's actually a problem that plagues the entire AI machine learning world on natural languages. How do you convert written words, text, into a machine readable file? And what ends up happening is that there are all sorts of solutions and techniques out there to reduce the noise on some of these documents. There's literally dozens of companies that are in the OCR business, some better than others. We've tried a number of them. The company that we're using right now, we think is the best in sort of identifying the best features without and then eliminating the noise. But it's possible that you have a document of a copy of a copy of a copy that you basically try to OCR, and it just comes, there's a bunch of gibberish, and there's nothing that can be done. My only solution there is, look, at the end of the day, if you're a legal organization and you have, let's say, 100 lawsuits coming through, and 5 of them have problems with OCR, well, then those 5 you may need to segregate for a human being to basically resolve, because if the OCR quality is bad, it's just junk in, junk out. And so, but it is a problem that we have. It's a problem that all AI companies have, is how do you reduce that? And it's a hard challenge.
You see it maybe in the near future being worked around by using PDFs that are readable from the start. I mean, technology is getting into courts and into the judicial practice. So
yeah, so in America, and I'm sure in Canada too, there's been a movement for the courts to automate their document management systems, and one of the requirements they now have is you have to send PDF files that are generated from the platform as opposed to a copy and then PDF. And so that's helped quite a bit. So like, for instance, federal lawsuits are typically that follow that format. A lot of the state lawsuits courts are beginning to follow that format too. And I think as lawyers become more savvy about document management, I think you're going to see that problem wane over the next several years. But there's still a few dinosaurs out there that like to still use highlighters and like to print out copies and make copies of copies of copies. I think over time that's going to mitigate.
Yeah, there's always a resistance to change, especially in our field, right?
Right.
Yeah. We're getting questions from the audience. You probably see them, but these ones that we received are in French. And maybe it goes back to my initial comment. And I don't know, I saw you close your files, but Tranjuk Antu is asking if we could see a few questions for the discovery in that chicken case that you showed. Is it too late for that, or I don't want to?
No, I mean, I can show it. Let me see here. Yeah, and if your audience would like, I'm more than happy just to send the files, because this is a demonstration file that I normally use, just because of I like I said, just the I'm just amazed at the extractions that it's able to get. So here's the
Well, for the audience, for the benefit of the audience, if any of you are interested in receiving these documents that James is offering, just write to me and we will arrange it.
Right. Yeah, I'll send those to you, and then you know, they can download it. But you know, it does a really good job of identifying. In fact, you know, if there's one complaint I think some people have had is it identifies too many allegations, and so you know, just a matter of trying to adjust those thresholds about relevancy and the type of entities and relationships that we're able to capture. But you know, it's like most of these are actually spot on in terms of you know, what are relevant allegations and why they may be important. And you know, some people will find some allegations more important than others, which is, you know, I think one of the topics that we're going to be talking about, which is a bias issue. Mm-hmm. And you know, one of the things I've noticed about lawyers in particular, and you know, I have this sort of fight all the time with our developers and AI modelers, because you know, as non-lawyers, what's interesting is that they somehow think that law is a science. They somehow think that there's a right and wrong answer. But you know, I think to the lawyers and paralegals in this audience, I think you all know that there's a range of right answers. Again, I'm going to borrow something from Malcolm Gladwell about, you know, the Prego pasta sauce. There is more than one favorite pasta sauce. There's a range of favorite pasta sauces. And what we found out is that you know, lawyers and paralegals are very much the same way. They're not scientists, they're artists. And because they're artists, the problem is they see the world a little bit differently than one another. And I can give this to everyone in your audience, and everyone in your audience will pick different things about what might be more important. And so the key is, how do you identify or match the profile, the preferences of a particular user with what a machine is likely to do? And you know, I think it's easy enough to sort of mimic and map out some of those preference issues, but you know, it is a challenge for the industry, I think, as a whole, because of this idea that you know, lawyers are artists, and you can't tell an artist to use a particular color palette all the time. It offends their sense of artistry. Anyway.
No, but it's very interesting. I would gladly jump into this question of biases right away. So correct me if I'm wrong, but what you're saying is that the AI system, it analyzes kind of one firm's, not biases, but maybe model. And when it replicates or when it creates the documents, it takes into consideration these biases that the lawyers working at the firm initially already have. Is that right?
Yeah, that's right. And so, you know, one of the things that we had to learn, and we discovered very quickly, is that our general purpose model, although I will tell you, I think you know, this output that you see is our general purpose model. It works great, and it really does a great job in sort of measuring broad-based preferences across, you know, the entire sort of group or industry. The problem is that as a particular user has, or a firm have particular preferences about the type of questions they like to ask, or you know, what defenses they like to assert. And so on our system, you can think of it as a big oak, like a big tree. You know, the main trunk is this model, but we branch off on this tree. Each firm, each organization basically has a separate branch. Each of those separate branches actually reflect their personal preferences as an institution or as a firm about what, you know, what preferences they have about how they want to deploy certain questions, how aggressive they want to be, etc. But you know, for our purposes, our general purpose models are, you know, is exactly that. We're trying to capture broad-based preferences across the entire industry, and then we tailor that for the organizations when they come on board.
That's very interesting. And you probably already had that question before, but isn't there a risk that I'm seeing while we discuss it, that, you know, a firm could take like a bad tangent or get into, or, you know, flaw the system, that it takes into consideration a bias that is actually, you know, wrong, or that falsifies, or not falsifies, but that affects the quality of the results?
I mean, yeah, and that's a problem with artistry, right? That some preferences, you know, some art I hate, And it's the same thing with this work product. What you'll find is not everyone will like it, and because they like their own stuff, and unless you're able to mimic their own stuff, they're going to reject it. And so, one of the analogies I have is, if you came up with an AI composing assistant platform, right, and you patterned it only after Bach, the only people that will use it are people who like Bach, right? If it was Stravinsky, he would hate it, right? If it was Mozart, he probably wouldn't use it. And it's because as artists, they have their own preferences. They have their own chromatic keys they want to follow, etc. And unless you're able to mimic the preferences of the person who's using it, it's doomed to fail. And that's something I think we all sort of need to recognize, as technologists, that the problem with AI is it normally just is based on one model. But the problem with one model is that model tends to be a compromise of many different preferences. And as you start deploying some of these things, unless you are talking about a science-based platform like math, where there's going to be a right or wrong answer. In law, there's a range of right answers and a range of wrong answers. And so until you're able to sort of mimic the decisions of what a human being is likely to make, it's doomed to fail.
We're getting questions from the audience, but just to maybe circle up on this topic, have you ever thought of applying this system to courts? And I suppose your position would be different regarding these biases if, let's say, a judge or interns of judges would start to use the system to, draft judgments for simple cases. I don't know. It's tons of possibilities that we could see there. I suppose this bias question would turn a little bit differently, right?
Yeah, I mean, judges are an interesting group of people, right? Because they're still human beings. People expect them to make consistent decisions, but as you guys know, whether you win or lose cases really often depends on the profile of the judge that you're in front of. And that's why there's appeal courts, specifically for that reason, because trial court judges make mistakes. And so the issue is, all right, how do you normalize that, right? How do you measure sort of these preferences? And how do you deem some preferences as bias and or not? I think it's an incredibly difficult task because you're trying to normalize human behavior. And that's an impossible ask, quite frankly. And so I think the best we can do is mimic what we think to be right decisions. But again, I'm really reminded of Malcolm Gladwell's Prego pasta sauce discussion. It's a mistake for us to all think that there's one right decision. I think there's a range of right decisions, and it's really going to depend on the particular circumstances of the case in front of us, before we can render whatever justice means.
Mm-hmm. And by curiosity, have you been approached by courts to try it in the?
We have not been approached by courts.
Okay, so you're not focusing on providing these kinds of tools to courts or to decision bodies?
Not yet. But I mean, you can see like in the courts being overwhelmed with cases, and the issue is 80-20 rule again. If you look in the federal courts, if you were to ask most federal judges what they hate about their caseload, it's probably habeas corpus petitions. And the idea is, is it possible to apply a platform like this to quickly judge, for lack of a better term, or triage these cases to basically figure out how they should be treated, put them in buckets, and then have a human being. We always want human beings to be the final arbiters of all this, to basically double check and verify and validate findings. And so that not only can justice eventually be served, but also we're collecting data to basically back propagate the model so that in the future, the models can make better predictions and suggestions.
Yeah, sure. Thank you very much. I mean, that we could go on this, but I just want to jump back to the questions from the audience. We have a few questions on jurisdiction. You showed that in your demo, you showed that you chose the state, for example? Do you have, well, actually, in what jurisdiction does this tool works, and do you apply it, and do you intend to come to Canada, for example? I don't know.
Yeah, so we're in now, I think, 11 or 12 states, and California, Texas, Florida, New York, basically the most populous states with the highest volume of litigation. And another strange, interesting fact is the top 20% of states has 80% of the litigation volume. So another example of where the Pareto principle really does apply. We've been approached by a few Canadian firms to basically expand to Canada, but the question is one of volume for us. As a startup, we have to be mindful about where we want to sort of progress. That doesn't mean that we're not willing to partner up with a Canadian partner to basically create a platform that can solve some of Canada's litigation problems. But none of us are Canadian lawyers. And so, you need to have subject matter expertise, obviously, to help navigate through the workflow of the laws, et cetera. But what we found out is, because English is fairly standardized around the world, our system does an incredibly great job in identifying, key allegations, even in text from the UK or even from Canada. So. I have no doubt that our system's able to have the natural language processing and understanding of even Canadian lawsuits. The question would then be, well, what's that second part of that look like in terms of what are the decisions that we need to sort of mimic based on sort of the identification and extraction that our system is doing.
Mm-hmm. And from this, I understand that it wouldn't be possible to test it on a Canadian case right now, because you have to set it up, right?
Right. And so, each of these, in fact, the reason why it takes so long in America to go from one state to the next is that this California output really is only for California. Texas looks very different. And so the type of questions they ask are different. The formatting is different. Some of the defenses you cannot make. And so those are some of the things that really it's going state by state is not so easy. I mean, even in Canada, I would assume that the provinces, the way that you guys structure your documents are going to be different. Maybe the state province laws, states of the province will be different as well. So you can see sort of the challenge when you go from province to province there as well.
Yeah, and just so you know, we even have one province where I'm talking from in Quebec, where we have a double system with civil law and common law. Mm-hmm. So whenever you get to Quebec, it's going to be an additional challenge for you, I think. But it would be very interesting to see. We have a question from Joel Hoa here, and he asks if you segment training models by jurisdiction as well. I understand the documents are different, but is the training model different by jurisdiction?
So what we found is, and when I tell this to people, they kind of laugh, but the way people slip and fall in Pennsylvania is the same as how they slip and fall in California, which means that what we're finding out is that the allegations that people make, even among the states, are fairly uniform. And so, when we started our company, we fully anticipated that we needed to basically train separate models for separate states. But what we found out was all we had to do was supplement and almost branch off. The primary model, which was California, and then California and some Texas, that was our primary model. And now we just branch off. And so if Pennsylvania has particular aspects of their law that California, the Texas model may not have, we branch it off and we include some additional training material to account for that. But by and large, our core models that we developed for personal injury and employment and insurance is relatively constant among all the states.
And just as a follow-up on that question from Joel, he actually asks too, do you see, since you have this main model, do you see any biases developing in matter-heavy jurisdictions? Like, yeah.
Well, so there are obvious biases, right? I mean, there's, and when I say bias, just preferences. I think we need to sort of label those appropriately. That there are preferences that certain law firms have in terms of the way they want to ask certain questions or defenses they want to answer. I want to divorce that from sort of the identification models that we've identified. And the importance there is we needed to get a great diversity of the way that plaintiffs' lawyers allege their lawsuits. And so there we needed to capture virtually every flavor of the way that a plaintiff's lawyer might be alleging particular aspects of the case. And so, and that number is a moving target. Sometimes it will just take 10 samples. Sometimes it takes 100. It really just depends on the complexity of the models. But what we were trying to do as subject matter experts, and because we had a number of lawyers on our team, was when we went and sourced lawsuits, what we tried to do was to get a good variety of different lawsuits from different lawyers from different areas, different regions, so that we can train an all-purpose model to identify key features. So like on this case, in terms of the rotisserie chicken, my guess is that we probably had other product liability cases in there and other products, not just, like I said, we had no cases involving rocks and chickens. So there must have been something else in here. Other food, I'm pretty sure we had other food product liability cases, which in California is a hot topic nowadays, is food liability. But I'm pretty sure we had a lot of other food liability. So it could have been drinks or it could have been another food product. But what we're able to do is take those and then, the models are very plastic. It's really amazing. I will say this, even if there was an OCR error, what I find is that even under the system that Watson has, it's able to ignore the OCR errors and look at words around the subject text to basically try to predict what it actually is. And so even with OCR errors, what we're finding is that it's still able to pick out the relevant allegations.
That's very interesting. And since you mentioned Watson, could you tell us a bit more, maybe? Because not all legal tech companies have the chance or the opportunity to work with IBM's Watson. Do you still work with them? Do they still, is the system still based on Watson? Or could you tell us a little more about that?
Yeah, so, when we started out, you have to remember this, like 4 or 5 years ago. Watson was a few years after the Jeopardy challenge. And people were still very much talking about the Watson platform. And when we dived into this, we actually evaluated a number of AI platforms at the time. And my view was Watson by far was the best of all the platforms available out there, both in terms of its ability to permit supervised training and providing an easy user interface, so that lawyers, we had a number of lawyers on our team basically help training the models. And you're dealing with lawyers, so you have to make it easy for them to train the materials. And the structured reports that we got back were amazing. And so, even to this day, Watson is our core sort of AI process, but we have other AI processes surrounding Watson. And so, again, I think the mistake people need to sort of understand, don't want people to make, is not relying on a single model. So even for us, Watson is one among several models that we deploy. I will tell you, I think for us, it's a great starting point and an ending point, because it's very, very good. But we still have other ensemble approaches so that we increase the accuracy of the predictions that we're making. So, but still to this day, we have a really deep relationship with IBM. Virtually every year we're featured on their IBM Think conference that they have. We're showcased as a really great example of how you can apply AI machine learning techniques to a very complicated area like law, and have a system understand and do these sort of extractions and identifications of legalese.
And you've probably seen the question, but it's very related. Marc Lajoie is asking, you say that you use different models, not only Watson. Do you use any open source software for NLP or machine learning?
Yeah, we use several, actually.
Oh, yeah?
So, the great thing about those open source models are they're open source, but the problem is they're open source. And the open source models do not anticipate legalese. Legalese is not English. Let me repeat that. Legalese is not English. It is a strange language lawyers use. And so, one of the great things that we discovered with Watson is that we were able to train a computer platform to recognize legalese and the relationship of words in legalese so that we can derive meaning and understanding. And like I said, I can tell you right now, you can try open source platforms to try to decipher legalese, not going to work. These open source platforms are really good at identifying, people, organizations, dates. That's it's good for that. But for other stuff like trying to understand like the particular relationships of allegations and identifying those allegations, you really need a supervised model to do that.
Yeah, and I think anyone who has tried or worked with AI in the legal domain has encountered these difficulties, and we did at the Cyberjustice Lab. We have a project where we work with case law, and it's exactly what you say it is. It's very different.
Yeah, and the problem is, if you remember from our user interface where you drag and drop, one of the questions we ask is, what is the domain? Mm-hmm. And the reason why that's important is this is a personal injury lawsuit, but if I ran this through the employment domain, I would get very poor answers because each of those models are really specifically primed towards identifying and understanding that domain. And it's really interesting. So if you went to any law firm and let's say you had an employment group and a personal injury group, and you gave a personal injury lawsuit like this to an employment lawyer, you'll get poor results, right? And it's the same thing with these models, and that's why we keep them highly segregated, because in order to increase the accuracy and decrease the noise, we need to have domain-specific models, and that also means the practice area. And so, for us, we were thinking about merging these two, employment and personal injury, but that would have been a mistake. And so, we made the right move segregating that because the features and understanding and the way that people make these allegations are very different between the two. And so otherwise you would have a model that would be overwhelmed with the number of things that would be you need to look for, and then the accuracy would start going down.
Yeah, and it's a very interesting decision, and maybe a bold one because it doubles the work. But I think you're totally right. Depending on the domain, even the same words even can have different meanings, right?
Right.
Yeah, we have a question maybe surrounding that from Mariette Pilon. She's asking if you could use your system in administrative law cases, as in National Labor Relations Board proceedings.
Yeah, so I think the answer is yes. I mean, we've also been asked to adapt our platform to administrative processes here in the U.S. So employment, EEOC type of stuff. And so we can, it's definitely possible. It's a matter of trying to hook up with the right data sources that an organization has. And so, for EEOC lawsuits, for instance, one of the challenges is oftentimes organizations will have done an investigation. And the question is, how do you capture that investigation, do the feature identification and extraction, so that you can then marry that with the allegations of the complaint, and so that you can have a comprehensive response. And so, it's stuff that we're working on now with a few clients, particularly some insurance companies, involving demand letters. So the idea is someone sends a demand letter. Okay, how do you answer that without information? And so, the idea is that we would be tapped into a database that is, identified by claim number or a policy number, and then we would be able to read and do the feature extraction, and then make the suggestions and predictions about what the response should be on how to respond. So it's one of the things that we're working on right now with a few clients and insurance companies, and I anticipate in about 6 months, I think we're going to have a production model released. But it is exciting that we would be able to have sort of a comprehensive interface where not only will you have a virtual assistant, but you'll have a text editor, and then you'll have access to the historical documents, so that all on one screen, you're able to deploy all these solutions.
Yeah, very interesting development to follow. Actually, I will be curious, and I'll be following your updates on that to see how it goes. Have you um, have you how would I say that? Have you had difficulties with data sources? I mean, getting them while you started developing your systems?
So when we developed, we had our own law firm, so we had access to our own data. But
Mm.
in order to supplement, we did have to source, again, public source documents. Lawsuits are public source, and so that wasn't as hard. And then when we onboard new clients, what we do often do is we ask for samples of complaints and their output of those complaints so that we can train our model on the back end to mimic some of those decisions. And so, that's been a little bit of a challenge actually, because oftentimes, not surprisingly, when law firms know that their samples are going to be used to train their own models, they want to pick the best ones. And this is a really good example of the artistry involved, because the person or people that are involved in picking those exemplars then really become judgmental about the performance of their own lawyers. And one law firm by mistake sent us some internal correspondence where they were concerned about the quality of some of the output that they had in their library. And so it really goes to show you that even within organizations, they know that they have problems. And so trying to pick the best ones for our system to mimic has been a challenge even for organizations.
Yeah, very interesting. And is the do you have a way to evaluate the accuracy of your results? Let's say you have this client, they sent you a bunch of documents to train your model. Do you give them like a number or percentage of accuracy, or do they evaluate and then get back to you with
Yeah, I mean, it goes back to this idea that our lawyers are artists, and it's really hard to come up with an accuracy score on these. But I will tell you internally, what we've done is we do have an auto quality assurance process where we are constantly checking to make sure that the 200 sample lawsuits that we have, we're able to identify the features that we think are important. The challenge is when you go to these organizations and they ask that question, they have a hard time figuring out what is accurate or not. Like, for instance, I can show you this output that you see on the screen, and every one of these are likely to be relevant. But the question is, someone might say, I don't really think this is that important, so therefore I don't think your system is accurate. Well, again, that's a preference issue. And that's a problem with this, is that it's almost like scoring Olympic diving. It is, you need to have 10 judges, and you have to get rid of the highest and lowest and get an average of the people in the middle. Because if you delegate that to one person, you're going to have different results every single time.
and it goes back to your comments when you were saying that the legal field is not science, it's not 2 plus 2, right? It's not math. So yeah, I suppose you had quite a few. It's like when you work in a service industry, right? Your service might be good for some, but less good for others. And getting back to this industry, since we don't have much time left, I would like to hear maybe your comments on how do you see lawyers adopting this, because that's very groundbreaking. It's new technology, AI and law. We hear about it. We hear uh, good feedback. We hear concerns. We hear a lot of stuff on AI in the legal field. How do you see that going forward?
So, I see the question by this lawyer about whether you can use this in deposition. And that is something that we do eventually
Mm-hmm.
plan to do. And you can imagine how it would work like this. You can ask questions, question answer, in a question answer format. And because of programs like LiveNote that transcribe, you can send those questions and answers to an AI platform that can identify the substance of the question and the answer, and then compare that to whatever might be in the historical record in the case, and then might be able to suggest ways of trapping the witness, of offering impeachment documents, follow-up questions. I mean, all sorts of things that a platform like this can assist in doing in real time, by the way. And that's really exciting, right? Because once you can now tap into discovery questions and responses, discovery documents, allegations in the complaint, and basically pull all that together in a sort of a central processing platform that can basically act as air traffic controller. This could really expedite the way that lawyers prepare for depositions, even ask depositions on the fly. So it's really exciting, and that's why I talk every now and then in front of students, particularly about this, and we talk about this idea of what does a future lawyer look like. Mm-hmm. And the future lawyer is going to look very different in 5 or 10 years than the lawyers today. And I have sort of one analogy, which I don't know if would be appropriate in Canada, because I understand you guys have managed healthcare, but in America, in the past 20 years, a concept called the urgent care centers have popped out of nowhere. And urgent care centers are almost like emergency room light facilities where, if you have a cold or if you have a cut on your finger that you want stitched, you can go to an urgent care center and they take very low level emergencies, not even low level medical care. And 20 years ago, you didn't see a lot of them. But I think what's happened in the past 20 years is in the American economy, they've recognized that you don't have to go to a hospital for all of your medical needs. And this thing called urgent care has now proliferated. It is such a huge part of the market now. And to the point where some insurance companies now require their insureds to go to an urgent care center first before they can be admitted to a hospital. And I think that's exactly what's going to happen in law. Clients are beginning to recognize that you don't have to go to a law firm for everything from A to Z when it comes to your legal needs. The reason why you hire a lawyer is because they're specialists in a particular field. All that early stage stuff, you can go to paraprofessionals. You can go to alternative legal service providers, which is becoming more powerful in America every day. And in the world, right? And so I think what's going to end up happening is that technology-backed platforms like ours are going to help that early stage stuff. And then what's going to end up happening is that the specialists in the legal field are going to be the ones that people really want. And so the generalists are basically going to be either phased out, or the generalists will have to learn some specialty skills, just like medicine here in America. The ones that are the most successful physicians are the ones who are specialists, they're not the generalists, because what's happening in this space is that the generalists are being, that whole market segment is being sort of merged into this sort of early stage medical care phase. And so I think that's what's going to happen here in law also, is that once technology becomes to integrated more in these phases, people will begin to realize that more of this early stage stuff will be it'll be extracted from that marketplace of a law firm. And law firms are going to be relegated to like the specialty type of matters, where that's where you want to hire a specialist like this. That's where you want to hire the Rembrandts of litigating cases than some of this early stage stuff. So that's what I think is going to happen in the next 3 to 5 years.
3 to 5 years sounds to me very optimistic now, considering the level of resistance that we usually see and have.
Yeah, I think that's right, but I think what you're going to see is, and again, I think in America there's this monopoly control over legal services, but everywhere in the world you have the big 4 accounting firms basically playing a much larger role in these sort of legal services, and in just a matter of time, I think that these ALSPs are going to start taking bigger chunks of the early stage market in America, where law firms, unless they're going to react to this, they're going to basically abdicate a huge portion of a potential revenue, quite frankly. And so it'd be an interesting thing to see. And I think we have a front row ticket to see this.
Yeah, you're right. We do. And maybe one last question. I'm very curious. Did you have any issues or processes or questions from the bars in the different states the bar associations in the different states that you are practicing in?
So not yet. And, one of the things that we were careful to do is we only license our product to lawyers and people who work under the supervision of lawyers, because, we see ourselves as a business to business platform. We don't license our stuff to consumers. You get into trouble right away when doing that. And so, our view is that we have to work within the confines of the restrictions that we have, and those are one of the restrictions.
You're right, and perhaps we will have this conversation because it was very interesting and informative. Thank you very much. So I think that's the end of it. Again, thank you very much for joining us. Very looking forward to how LegalMation will be doing and your new developments that you've mentioned.